everyone, my name is Bin Ruichen, and those are my group member, Gui Jingshan, Xin Guo, and yeah. So today we present the sexual orientation in Australia, the case before in 2017. The case background, what happens, the role of the Mr. Tiffany was worked for the Burgess company. The Burgess company is registered in Australia for property. Then when the Miss Tiffany worked from January 2016 to January 2016, at the end of the internship, the company was fired him. So in the following case, we will discuss the issue from Gui Jingshan.
So it is my turn to discuss the issues furthermore about this case to all of you. So first of all, basically it's all the recording and the evidence, both of the applicants and the defendants provided to the court. So we can see the general information for the applicant was employed in the administrative, so from the December in 2015, and there was a probation period for like half a year. So during this period, she took the sick leave for a total of 7 days, which is I think it's not a very serious problem, and multiple times for the work. But as the applicants stated, it was only a few minutes late. And when she informed the employer that Mr. Perrin that she was pregnant and wanted to take a maternity leave, so as a result, she got fired at the end of her probation period. Although the Ms. Perry, which is the respondent of the company, said there's nothing, this result has nothing to do with the sick leave or the idea that she want to take the maternity leave, but it's only because of her unpunctual attendance and maybe they failed to do the work. But the applicants think that is everything to do with the pregnancy, the fact. So because the applicant said that Ms. Perrin even praised her for her work ethic, so she thinks the ability of the work is okay. So we need to discuss about this by the rules indicated. So Song Zhou will discuss the rules from this one.
Yeah. And for the court, they decided to amend Fair Work Act. The first one is made by 2009. It's called Sect 340, Protection for Employees, and the second is Sect 351, Discrimination, by dismissing applicant because she is pregnant. And for another rules is Fair Work Regulations, also added in 2009. And I will talk about the provision, a legal provision 342 first. It provides the adverse action includes employers dismissing an employee, and the second is the 351. First part of 351. It is it provides that an employer must not take adverse action against a man who is an employee of the employer because of the person's race, color, sex, sexual orientation, age, physical or mental disabilities, families, careers, responsibility, pregnancy, religion, political opinion, and nation extraction or social origin. And I will talk about the 352, temporary absence. Okay, later, I will talk about an employee must not dismiss an employee. Employer must not dismiss an employee because the employee is temporarily absent from the work because of the illness or injury or pregnant as well. And this kind of prescribed by the regulations. And also in 360 Act provides that for the purpose of this part, a person takes action for a particular reason if the reasons for the action includes that reason. Okay, and let's introduce our other group member to talk about something more, applications.
Yeah. Now let's talk about the applications. In this case, as the director of the respondents, Mr. Perry made the final decision to terminate the applicant employment. The reason is, firstly, is make regular mistakes in his performance, and the otherwise is poor punctuality. In fact, before the applicant report she's pregnant, the Mr. Perry has praised her for her work ethic in a career meeting. He also offered a new working program in the account department for her, and that will involve the pay increase. Secondly, about the punctuality, all 7 times to request for day off and the 5 times late is all happened after the applicant's pregnancy. And each time the applicant has communicated with his leader, the Mr. Perry. And also she also provides all the medical certificate all the time. Thirdly, as the direct leader, Mr. Perry has never formally raised any issues regarding performance and punctuality for applicants. That has therefore not given any opportunity to correct his performance. According to all evidence, we have to consider the applicant's gender and her situation with the pregnant. That is the reason why she got the dismissal. Now, we'll make the conclusions.
Therefore, Mrs. Tiffany is pregnancy and gives when he gets illness and gives medical certification for the company. So the company breaks the duty of care for the Miss Tiffany. Miss Tiffany gets protection from the legally section in Act. So next, and the counter will give the decision at the next judgment.